NFA 1934, HR 9006. The National Firearms Act fit in perfectly with the systematic creation of government programs and deficit spending that Franklin Roosevelt immediately began to institute the instant he took office. The NFA was a model vehicle for the continued expansion of government power. It was arbitrary. It gave the government sweeping authority over something very common. It focused on inanimate objects rather than criminal behavior. It levied draconian taxes on these objects. And most certainly, it created millions of criminals with the stroke of a pen, just as Prohibition had. Now, John Ross. The National Firearms Act, NFA, of 1934 marked the beginning of modern federal gun control legislation, and its impact continues to be felt almost 90 years later. Gun shops, online forums, and social media posts remain filled with questions about NFA compliance, as gun owners seek to avoid legal penalties for owning short-barreled rifles, SBR, short-barreled shotguns, SBS, suppressors, machine guns, destructive devices, and other restricted items. Despite this widespread awareness, many gun owners are unfamiliar with the origins of this landmark legislation, the origins of the NFA. To understand the NFA's origins, it's important to consider the historical context. Prohibition had ended just a year earlier in 1933, and the country was in the midst of the Great Depression. This was also an era of rampant gang violence, with infamous criminals like Al Capone dominating headlines. The early 1930s were arguably among the most violent periods in American history. Gang violence, driven by the Prohibition-era's black market, was the primary catalyst for the NFA, but it wasn't the only factor contributing to national unrest. In 1932, civil unrest erupted when the Bonus Army marched on Washington, D.C., demanding compensation for their World War I service. That same year, the business plot sought to overthrow President Franklin Delano Roosevelt, and an assassination attempt was made on his life in 1933. The nation was a powder keg of social and political tension, and the government sought new ways to control the chaos. On April 16, 1934, Attorney General Homer Cummings presented HR 9006 to the House Committee on Ways and Means. Cummings aimed to use Congress's power of taxation and interstate commerce regulation to crack down on gangsters. He claimed that the criminal underworld had 2 to 3 times more people than the Navy and Army combined, estimating around 500,000 gangsters. He proposed using the NFA to create new federal crimes, particularly targeting unregistered machine guns, in order to prosecute criminals who otherwise evaded justice, similar to how Al Capone was eventually imprisoned for tax evasion. Cummings also drew inspiration from the Harrison Narcotics Act of 1914, which used taxation to regulate drugs. This model of using taxes to indirectly regulate firearms would become the foundation of the NFA. The true purpose of the NFA. During congressional hearings, Assistant Attorney General Joseph Keenan admitted the government's limitations.
We are fully alive to the grave possibility that we will not keep the criminal from getting firearms, but we do hope to make it a simple matter to put them behind bars when they violate these regulations.
Keenan acknowledged that the NFA would not prevent hardened criminals from obtaining guns, but it would provide a legal means to prosecute them. The NFA was less about disarming criminals and more about creating a legal trap for those who possessed unregistered firearms. Cummings originally sought harsher measures, including the registration of all firearms, including handguns, magazines, and semi-automatics, as well as outlawing bulletproof vests. In his words,
"A machine gun ought never to be in the hands of any private individual. There is not the slightest excuse for it, not the least in the world."
Despite these ambitions, some lawmakers questioned the constitutionality of these measures. Congressman James McClintock of Oklahoma asked Cummings if the federal government had the constitutional authority to mandate registration. Cummings conceded that such a provision would likely be unconstitutional, which led to a more limited version of the NFA being passed. The role of the NRA. The National Rifle Association, NRA, played a significant role in shaping the final version of the NFA. Although the NRA ultimately supported the act, they were responsible for softening many of its provisions. The original bill would have classified all semi-automatic firearms as machine guns, but the NRA lobbied to narrow the definition. They also helped reduce the tax burden on manufacturers and dealers. Frederick and General Record of the NRA were instrumental in preventing handguns from being included in the NFA. Frederick testified before Congress, arguing that the proposed regulations would not stop criminals, but would instead hinder law-abiding citizens.
In my opinion, most of the proposals for the regulation of firearms, although ostensibly and properly aimed at the crook, do not reach the crook at all, but they do reach the honest man.
Frederick emphasized the importance of civilian self-defense and pointed out that criminals often obtain their firearms through illegal means, making it unlikely that the NFA would deter them. If it weren't for the NRA, specifically Frederick and General Record, Congress would have certainly included all handguns in the NFA. I have seen numerous blurbs about what was said by Frederick during the NFA hearing. In the past, I was utterly annoyed. However, after reading the 4 days of transcripts from the hearings, it isn't as damning to me as I previously thought. I concede that while reading, you want them to say certain things differently, but frankly, we are seeing it through the eyes of 85 years of gun control. We fully understand the slippery slope and ineffectiveness of gun control now.
You have put your finger on it. My general objections to most of the regulatory provisions are proposed with that in view. I am just as much against the gangster as any man. I am just as much interested in seeing him suppressed, but I do not believe that we should burn down the barn in order to destroy the rats. I am in favor of some more skillful method of getting the rats without destroying the barn. In my opinion, most of the proposals, the regulation of firearms, although ostensibly and properly aimed at the crook, do not reach the crook at all, but they do reach the honest man. In my opinion, the forces which are opposed to crime consist of two general bodies. One is the organized police, and the second is the unorganized victims, the great mass of unorganized law-abiding citizens. And if you destroy the effective opposition of either one of those, you are inevitably going to increase crime, because as you destroy the forces of resistance in the human body to disease, you are going to increase disease. So, by destroying the resistance of anybody which is opposed to crime, you are going to increase crime. I think we should be careful in considering the actual operation of regulatory measures to make sure that they do not hamstring the law-abiding citizen in his opposition to the crook.
Frederick goes on to explain what we have all been saying for years and what has been said for centuries. Criminals don't obey laws.
I think that is the opinion of any person who has knowledge of the subject. In most instances, the guns are stolen. They are not gotten through legitimate channels. Dillinger stole his guns. I have a half-dozen cases where guns have been used in prisons to effect a break. We have had that in New York and all over the country. If you cannot keep guns out of the hands of criminals in jails, I do not see how you can keep them out of the hands of criminals walking about on the public highways.
Frederick further goes on to explain civilians stopping crimes to which Congress was completely stumped by. They had never heard of a case of defensive gun use. This case set a precedent that I believe no one was ready for, least of all the NRA, who was barely, if at all, a lobbying arm at the time. That is clear given that Frederick had to explain who the NRA was to Congress, even though Congress had appropriated around $500,000 to the NRA previously for firearm training. Maneuvering around the Constitution. The most telling statement from Attorney General Cummings during the hearings reveals how the NFA was designed to circumvent constitutional limitations.
You see, if we made a statute absolutely forbidding any human being to have a machine gun, you might say there is some constitutional question involved. But when you say, we will tax the machine gun, you are easily within the law.
Cummings and his colleagues understood that an outright ban on firearms would face constitutional challenges, so they used the power of taxation as a loophole to regulate weapons. The legacy of the NFA. The NFA, as passed, imposed a $200 tax on the sale and transfer of specific firearms, a figure that remains unchanged to this day. Although it may seem minor now, this tax was equivalent to a significant portion of the cost of a firearm in 1934. The bill also imposed strict regulations on suppressors, silencers, although there was little discussion in the hearings about why they were included. While the NRA is often criticized for supporting the NFA, it is important to recognize that they played a crucial role in preventing the act from being even more restrictive. The NFA was a pivotal moment in U.S. gun control history, setting the stage for future legislation like the Gun Control Act of 1968. Frederick's words during the hearings resonate today. Regulations aimed at criminals often end up penalizing law-abiding citizens. The NFA's legacy continues to influence the gun debate, and its origins serve as a reminder of the delicate balance between public safety and individual rights. 1938 Federal Firearms Act, FFA. The Federal Firearms Act of 1938, FFA, is an early piece of gun control legislation that often flies under the radar compared to its more infamous successors, like the Gun Control Act of 1968. However, the FFA marks a significant step in the gradual expansion of federal gun control laws in the United States. Following on the heels of the National Firearms Act, NFA, of 1934, the FFA was another attempt to regulate firearms under Congress's power to tax and regulate interstate commerce. The FFA specifically focused on the sale of firearms and ammunition. It required firearm dealers, manufacturers, and importers to obtain a federal license, and mandated that they keep records of all firearms transactions. Key provisions of the FFA. Licensing requirements. The FFA introduced a licensing requirement for dealers, importers, and manufacturers of firearms. These licenses were issued by the federal government and were necessary for anyone engaging in the business of selling firearms across state lines. Prohibited persons. The FFA prohibited the sale of firearms and ammunition to individuals who were known or believed to be under indictment, fugitives from justice, or those who had been charged with a crime of violence. However, it did not apply to all felons. The focus was on individuals associated with violent crimes, meaning that many nonviolent felonies were not covered by the Act. This distinction is important, as modern gun control laws often blanketly prohibit all felons from owning firearms, regardless of the nature of their crimes. Record keeping. Dealers were required to maintain records of all firearm sales. This was one of the early federal attempts to create a paper trail for firearm transactions, although the Act did not include mechanisms for enforcement or verification, such as background checks. One interesting aspect of the FFA is that .22 caliber rifles were largely exempt from many of the provisions. This exemption likely contributed to the popularity of the .22 caliber rifle in the mid-20th century and explains why many retailers like Sears, JCPenney, and Montgomery Ward carried extensive lines of .22 rifles under their own brands. Impact and limitations. The FFA is often overlooked because it was not very effective in practice. While it established some early frameworks for regulating the sale and ownership of firearms, it lacked enforcement mechanisms. For instance, there was no background check system in place to ensure that prohibited persons, those indicted for violent crimes, could not purchase firearms. It was still possible to buy a gun through the mail, which meant that many of the FFA's provisions were easily circumvented. Gun control advocates often point to the FFA as a precursor to more robust laws like the Gun Control Act of 1968. However, from the perspective of the pro-gun community, the FFA represents the beginning of a slippery slope. What started with the NFA as an effort to tax and regulate specific types of firearms expanded with the FFA into broader regulation of firearm sales and transactions. 30 years later, these seemingly limited and ineffective laws would gain real teeth with the passage of the Gun Control Act of 1968. Ultimately, the FFA is a key part of the history of U.S. gun control, laying the groundwork for more expansive federal regulations that would come later. 1939, United States versus Miller. Fast forward a few years after the passage of the National Firearms Act, NFA, and the law faced its first major constitutional test in the case of United States versus Miller. Jack Miller and Frank Layton were indicted in 1938 for transporting an unregistered short-barreled shotgun across state lines, a violation of the NFA. The case is often discussed in the context of gun rights and the Second Amendment, but much of the historical narrative depends on how one views the defendants. Depending on the source, you might read that Miller and Layton were either bank robbers or moonshiners. Some pro-gun articles avoid mentioning their criminal background, likely because they see it as irrelevant to the Second Amendment debate. Regardless of their character, the importance of the case lies in how the courts interpreted the constitutionality of the NFA, not in the personal history of the defendants. The case. Jack Miller was associated with the O'Malley gang and had been involved in bank robberies. His need for a firearm for self-defense became urgent after 4 of his gang members escaped from custody, with 2 later captured and 2 killed. Miller's life ended in violence, shot multiple times with a .38 special during a robbery. However, the Supreme Court case that bears his name has much less to do with his character and everything to do with the legal implications for the Second Amendment. On January 3, 1939, Miller's attorney, Paul Gutensohlen, argued that the NFA violated the Second Amendment. The U.S. District Court for the Western District of Arkansas agreed and declared the NFA unconstitutional. However, the federal government was determined to uphold the law, and U.S. Attorney General Clinton Berry appealed the case to the U.S. Supreme Court. The Supreme Court set the case for March 30, 1939. However, 2 days before the hearing, Gutensohlen informed the court via telegram that he could no longer represent Miller and Layton, as they could not afford his services. Neither Miller nor Layton made the trip to Washington, D.C. Layton couldn't afford it, and Miller was already dead. The decision. The Supreme Court heard the case without any representation or defense for Miller and Layton. There were no briefs submitted on their behalf and no oral arguments presented to counter the federal government's position. Despite the lack of a defense, the justices unanimously upheld the NFA's constitutionality. Justice James Clark McReynolds, delivering the court's opinion, wrote,
"In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length, at this time, has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly, it is not within judicial notice that this weapon is any part of the ordinary military equipment, or that its use could contribute to the common defense."
The key issue in McReynolds' opinion was the lack of evidence showing that a short-barreled shotgun had any relation to militia use or military equipment. Had a defense been presented, it could have made a significant difference in the case. Historical records show that short-barreled shotguns were indeed used by military forces, including the 16-inch naval blunderbuss and other firearms with barrel lengths under 18 inches. Legal and historical context. Like the congressional hearings on the NFA 5 years earlier, this Supreme Court case lacked a thorough examination of the Second Amendment. Although Miller was the first case to bring Second Amendment questions to the Supreme Court, the court's decision was based on incomplete information and a one-sided argument. Despite his reputation for being difficult and sometimes prejudiced, Justice McReynolds was not necessarily biased against gun rights. He had previously opposed President Franklin D. Roosevelt's attempts to expand federal power, and the Miller decision should be seen within this broader judicial philosophy. McReynolds was described by the Christian Science Monitor as
the last and lone champion on the Supreme Bench, battling the steady encroachment of federal powers on state and individual rights.
What can be gleaned from this case is limited, as the defense was not present and no substantive arguments were made against the NFA. However, the prosecution's stance provides some insight into how the government viewed the Second Amendment at the time. The prosecution's argument. The prosecution in Miller acknowledged that the right to bear arms was not granted by the Constitution, but was a pre-existing natural right.
The Second Amendment does not confer upon the people the right to keep and bear arms. It is one of the provisions of the Constitution which, recognizing the prior existence of a certain right, declares that it shall not be infringed by Congress.
This recognition of the right to bear arms as a natural right is crucial. However, the prosecution then argued that this right should be understood through the lens of English common law as it existed at the time of the American Revolution. They cited the historical context of English rulers disarming their political opponents and argued that the Second Amendment was meant to arm citizens as a collective body, not for individual self-defense.
This right gave sanction only to the arming of the people as a body, to defend their rights against tyrannical and unprincipled rulers. It did not permit the keeping of arms for purposes of private defense.
This interpretation ignores the broader context of the founders' intentions. While the English Bill of Rights influenced the Second Amendment, the founders expanded on these principles to ensure that individuals had the right to self-defense. The U.S. Constitution and Bill of Rights were designed to protect individual liberties, including the right to bear arms. Conclusion. In the end, Miller was not a fully tried case, and the constitutionality of the NFA was upheld without any opposition. The Second Amendment and the concept of a well-regulated militia were barely examined. Had the defense argued the militia's role or cited historical examples of militia arms, the case might have turned out differently. Unfortunately, Miller has not been challenged in the Supreme Court since, leaving its one-sided precedent largely intact.